justice. No less than His Excellency President Bongbong Marcos has pledged and guaranteed that human rights would be protected during his term. The CHR, as the National Human Rights Institution of the Republic of the Philippines, and mandated to protect and promote the human rights of every Filipino, we are of the position that that the Commission will cooperate if the ICC so requests, and the extent of our cooperation would be determined in accordance with the specific request of the ICC and within the mandate of the Commission on Human Rights. Thank you very much.
All right, thank you. We have the Center for International Law, Attorney Gilbert Andres, the Executive Director. You recognize, please.
Good morning, Mr. Chairs, and good morning, Your Honors. Your Honors, is the position of the Center for International Law that we should cooperate with the ICC. And we urge the approval of the 3 House resolutions on 6 grounds. In fact, Your Honor, I will not start with public international law. I will start with Philippine domestic law, because in fact, this Honorable House, together with the Senate, passed in 2009, RA 9851. What is RA 9851? It's the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. It was signed into law on December 11, 2009. In fact, Your Honor, what was the context? Why is it that this Honorable House and the Senate passed 9851? Because at that time, we signed the Rome Statute, but we were not a state party to the Rome Statute, because the President did not send the ratified Rome Statute to the Senate. Hence, there was actually an advocacy campaign for the Philippines to satisfy its international obligation under international humanitarian law, under the Geneva Conventions. And we have ratified all of the Geneva Conventions. Hence, Your Honors, your Congress passed RA 9851. And what does RA 9851 provide? Your Honors, I want to refer you to Section 17 of RA 9851, because it actually provides for the reverse complementarity principle. And I will read it, Your Honor, and I want to place it on the record, that relevant portion of Section 17. And I quote, "In the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime punishable under this act if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crime. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state pursuant to the applicable extradition law and treaties." Hence, Your Honor, what is actually provided in Section 17 of RA 9851 is reverse complementarity. In fact, the Philippine authorities may just opt to just surrender an accused person before an international tribunal, such as the ICC. And Your Honors, in Senator Pangilinan versus Cayetano, the Supreme Court actually referred to this principle of reverse complementarity. How do I know? I was actually, Your Honors, a petitioner and a counsel in that petition, PCICC versus Executive Secretary. Hence, Your Honor, it's actually an exercise of sovereignty for the Philippines to cooperate with the ICC, because it's provided for under Section 17 of RA 9851. Your Honor, our second point is important, especially in the context of the West Philippine Sea dispute. Our Philippine Coast Guard, our Filipino fishermen, they have been harassed by the Coast Guard or by the militia of a certain state in the north, a powerful state. And what have we been invoking always? We have been always invoking international law and compliance with a rule-based international legal order. In fact, Your Honor, the arbitral award that was decided on July 12, 2016, Philippines versus China. It's based on international law, the UN Convention on the Law of the Seas. And it's a historical fact that China does not recognize the jurisdiction of the arbitral body. China does not recognize the arbitral award. And yet it does not invalidate the arbitral award that we have won, and which we have won not just for the Philippines, but for the region in Southeast Asia. Because we say that we should adhere to international law and a rules-based international legal order. Hence, Your Honor, if we be faithful with that consistent plea of the Philippines for international law, we should also be consistent with our international obligation under the ICC Rome Statute, which leads to our third point. Your Honor, the Philippines was actually part of the delegation of plenipotentiaries in the ICC Rome Conference in July of 1998. We actually sent a delegation to actually participate in the drafting. And we were actually very active in the drafting of the ICC Rome Statute. In fact, Your Honor, we signed it in December of 2000, except it was not passed for concurrence by the Senate. And when it was signed, it was actually ratified by the President. It was sent to the Philippine Senate for its concurrence. And in fact, during the deliberations before the subcommittee, then chaired by Senator Miriam Defensor Santiago, agencies of the government actually supported the concurrence of the ratification. What agencies were these? These were the DOJ, the DFA, the Philippine National Police, the Armed Forces of the Philippines, the Commission on Human Rights. They actually approved and supported concurrence into the ICC Rome Statute. And Your Honor, on August 23, 2011, the Philippine Senate, on a vote of 17-1, passed, concurred into the ICC Rome Statute. And you can see from the records who were one of the 17 senators. It was then Senator Ferdinand Romualdez Marcos Jr. Yes, he voted for the approval, the concurrence of the Rome Statute ratification. And Your Honor, it's presumed that legislators actually do their official business in good faith, that you have read all the drafts, all the bills, all the resolutions that you are actually voting upon. And Your Honor, in fact, if we were a state party to the ICC, it means that we are obligated under the ICC. And in fact, there's actually a residual obligation, even though we withdrew. It's in Article 127 of the ICC Rome Statute. And I want to refer Your Honors to Article 127. In fact, it's an important article because it's precisely the article that the Philippines invoke in order to withdraw. That's paragraph 1. But in paragraph 2 of Article 127, it provides for a residual obligation. And I want to quote that verbatim in paragraph 2. And I quote, "A state shall not be discharged by reason of its withdrawal from the obligations arising from the statute, while it was a party to the statute, including any financial obligations which may have accrued. Its withdrawal shall not affect any cooperation with the court in connection with criminal investigation and proceedings in relation to which the withdrawing state had a duty to cooperate and which were commenced prior to the date on which the withdrawal became effective. Nor shall it prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective." And Your Honor, again, in Pangilinan versus Cayetano, the Supreme Court referred to Article 127 of the ICC Rome Statute, and even it actually affirmed our residual obligation under that provision. In fact, it says that we really have to cooperate based on Article 127, paragraph 2 of the ICC Rome Statute. Which leads, Your Honor, to my fourth point. Your Honor, complementarity has always been said to be a provision wherein the ICC will come in if the state is unwilling or unable. Your Honor, to be honest and to be frank, with all due respect, that's actually a misconception. Why? Because if you want to look at complementarity as a principle, you have to look at Article 17 of the ICC Rome Statute. And Article 17 of the ICC Rome Statute has 3 paragraphs. 1, 2, 3. This is the architecture. Paragraph 1 refers to any situation, any cases that are not admissible before the ICC. And what are these cases which are not admissible to the ICC? These are cases wherein an investigation or a prosecution has been done, okay, except the state is unwilling or unable to genuinely prosecute or investigate. Meaning to say, Your Honor, if you just look at the grammar, the text itself, it presupposes that there's an investigation or a prosecution for international crimes. Now, if there's an investigation or prosecution, then the ICC will look, is this investigation or prosecution, is it really genuine? Or the state is unwilling or unable to genuinely, and I'm saying that, genuinely, to emphasize, investigate or prosecute. Hence, Your Honors, it means that if the state is not actually investigating or prosecuting, then that's the time that the court, the ICC, will do its complementary jurisdiction. Why? Because the state did not do its primary jurisdiction to investigate international crimes. And the context here, Your Honors, these are not just simple crimes. These are most serious crimes of concern to the international community. In fact, these are international crimes, war crimes, genocide, crimes against humanity. And we had that experience, Your Honors, during the Japanese occupation. 100,000 Filipinos were murdered, looted, raped, burned in Manila from Feb 3 of 1945 up to March 3 of 1945. 100,000 Filipinos. And that's a war crime. In fact, there was a prosecution, Yamashita versus Tyre. That's a prosecution for war crimes. Hence, Your Honor, that's the reason why if the state is not doing its primary duty to investigate international crimes, then the ICC will come in order to prevent impunity. That's why the question is just simple. Has there been investigations or prosecutions for crimes against humanity, which is actually a crime under RA 9851? I think Section 7. Has there been actual investigations on crimes against humanity that occurred on the Philippine territory from November 1, 2011 up to March 16, 2019? And you can determine that for yourselves. The resounding answer is none. Therefore, Your Honor, the ICC is not a supranational, it's not a supranational court. It's not a world justice system that will look whether or not you're unwilling or unable, Your Honor. Last, Your Honor. In fact, Your Honor, even non-state parties can actually recognize the ICC's jurisdiction. That's under Article 12, Paragraph 3 of the ICC Rome Statute. In fact, Ukraine, it's not a state party, and yet it referred its situation to the ICC. Hence, there was an arrest warrant for Vladimir Putin. Lastly, Your Honor, the Philippines has been at the forefront of the international justice system. In fact, Your Honor, the Philippines actually contributed to international criminal law in Yamashita versus Tyre, the doctrine of command responsibility. That's because of Philippine jurisprudence. And Your Honors, there's actually a very famous concurring and dissenting opinion by Justice Gregorio Perfecto, and I want to read it on the records. He said that in the violation of the law of nations, the offended party is the people of the whole world, and the case against petitioner could be properly entitled as Humanity versus Tomoyuki Yamashita. And no person in position to prosecute the violators can honestly shirk the responsibility of relentlessly prosecuting them, lest he be branded with the stigma of complicity. Your Honors, our appeal is to also look at it from the viewpoint of the victims. Mga balo po, mga anak, mga kapatid, mga ina, mga ama, na nawalan po ng kanilang mga mahal sa buhay dahil po sa EJK, sa war on drugs. All they're asking is justice. And since it's a fact they did not get justice from the previous administrations, they're asking it from the ICC. And we hope that this August body will really ask the Philippines to cooperate with the ICC for the sake of justice. Maraming salamat po.